Legacy Builders, welcome back to the second lesson in the OPIP, Other People's Intellectual Property, chapter of the IP for Business Blueprint course. I'm Jenn McNeely with JWM Designs and Marketing, and in this video lesson, I'm going to share with you my process for finding the owner or owners of a copyright. Before you get into this lesson, make sure you review your notes on the prior lessons where I discuss the basics of copyrights, trademarks, and fair use. Why now? In the last lesson, I explained the importance of getting permission to use other people's intellectual property and the potential consequences for failing to do so. Before you can get permission, you need to know who owns the rights to the intellectual property that you want to use. This is usually a fairly easy process and can be done simply by looking at the copyright notice that accompanies the work. Unfortunately, you can't always count on there being a copyright notice attached to the work because the notice is not required for works published after March 1st, 1989. Another challenge that may arise in the search for a copyright owner is when there are multiple owners of the work. In those situations, you will need to get the permission of all the owners to use the work. As you've probably guessed by now, there are times when you will have to do some serious detective work to find the owner. Remember, under certain circumstances, the author of a work may not have the authority to grant permission to use the work, and any permission they give you could be worthless when defending yourself in court. In situations where you can't readily identify the copyright's owner simply by looking at the copyright notice, you can follow the steps in this lesson to find the owner and get the proper permissions you need for every project. Start with what you know. Because the ownership of a copyright is easily transferable, identifying the owner of a copyright can be difficult. There are several factors that can make the process more difficult, such as the type of work, whether the work was made for hire, who actually made the work, and whether the work was sold. The first thing you need to do is list out what you know about the copyrighted work, starting with identifying the category the copyright material belongs to. Is it a literary work, a computer software program, a photograph, or a sound recording? This is a huge factor in planning your search for the author because each industry has a different process for recording and maintaining copyright records. For example, most literary authors transfer all or part of their copyright ownership rights to a publisher for the duration of their lives, and upon their deaths, the rights may transfer back to the author's estate or their heirs. If you can identify the publishing company for the work, you can start by contacting them to see about getting permissions. Most publishing companies keep detailed records of their copyright ownership and any records of transfers of ownership of works that they may only hold a non-exclusive license to. In your ebook, I list several sources that you can use in your search for a copyright owner, separated by categories like music, literature, photography, and a few others. Another key factor is whether the copyrighted work was created in a work-for-hire situation. A work made for hire is one created by an employee within the scope of his or her employment, or created by an independent contractor hired under a written contract to create commissioned projects. A work made for hire belongs to either the party who commissioned it or the party who employed the creator, but not to the party who created the work. An example of an employee work for hire would be an app developer who is an employee of Apple Inc. that creates an Apple software program. Because developing software is within the scope of his or her employment with Apple, the copyright owner would be Apple and not the individual employee. An example of an independent contractor work-for-hire situation would be where both parties sign a written work-for-hire agreement and the work itself fits in one of 9 categories. In order for a work to qualify as a commissioned work-for-hire, the agreement has to be signed before the work is completed. I've listed the work-for-hire categories and template work-for-hire agreements in your e-notebook for this lesson. One thing to keep in mind when searching for the owner of a copyright is when the work was originally created. Works published in the U.S. from January 1, 1923 to December 31, 1963 require renewal with the United States Copyright Office, and a quick search of the renewal records could lead you to the work's owner. In your e-notebook for this course, I have listed links to where you can do searches for different copyright categories and years of publication. Conducting the search. Once you have identified some of the basic information about the work that you want to use, you need to start inputting that information into search databases. I would suggest that you start with the Library of Congress, the largest depository of copyrighted works in the U.S. This is a great place to start your search because you don't need to be overly specific in your search query. You can search for general information like the title of the work, last known author, date of publication, publisher, or subject matter. You can then take the results of that search and input it into the search query for the United States Copyright Database. When searching the U.S. Copyright Office database, you want to look for certificates of registration and see if there has been any assignment or other transfer filed for that copyrighted material. The certificate of registration tells you who originally owned the copyright, and the other assignment or licensing records will tell you who currently owns that copyright. Public domain. I want to note at this point, just because a work has been registered with the Copyright Office does not mean that that work is still protected. As I mentioned in a prior lesson, if a work is not protected under copyright law, it is in the public domain and can be used without permission. The four main ways a work will fall within the public domain is that the copyright is expired, the owner did not follow the required rules for renewal, the copyright owners intentionally place the copyright in the public domain, or the copyright law doesn't protect the work. Because copyright protection only lasts for a set period of time, at some point, all copyrighted work will enter the public domain. For works published and registered between 1923 and 1963, the copyright owners were required to file a renewal of their registration with the Copyright Office in order to maintain protections. If they did not, the works fell within the public domain. For works published between 1964 and 1977, the works are protected for 95 years. All works created after 1977 are protected for the life of the owner plus 70 years. For older works, when conducting a search on the United States Copyright Office, look to see if a renewal was filed for that copyrighted work. If a work was published before 1923, it is likely that that work is now in the public domain. Speaking of the public domain, a question I often get is what is the difference between a public domain and a Creative Commons? A creative work that falls within the public domain can be used without permission or restriction. However, there are times when authors of a creative work want the public to have general access to the work with very limited restrictions, and so they place the work in a Creative Commons licensing scheme. Under a Creative Commons license agreement, authors permit individuals and businesses to use their creative work with little to no restrictions. There are 6 license types within the Creative Commons licensing scheme, and you need to make sure that the license granted to you gives you permission to use the creative work the way that you intend to use it. With some licenses, the owners of the work may not charge a fee for the use, but they will require you to credit them. Some licenses allow you to modify, distribute, and build on the original work, but you cannot use that work for commercial purposes. I have created a Creative Commons cheat sheet in your e-notebook for this course so that you can reference it when looking at materials online. Something I want to mention is that many business owners, including me, use stock photo companies to license videos, photographs, and other designs in exchange for a fee. Most of the stock photo companies are licensing agents for the original author of the creative work and have the authority to grant you a license. Be sure to read the terms of agreement for each work you license with these companies. For example, Adobe Stock Photo allows you to license their works for commercial use, but also some for editorial use. Be sure you know what you are licensing and what permissions you are being granted. In the e-notebook that accompanies this course, I list my go-to places for stock images, music, and graphics. Requesting permission. Once you've identified whether a work is still protected by copyright and who currently owns the rights you seek, it's time to make the ask. In your e-notebook, I have a template permission request letter that you can send to copyright owners to request permission to use their works. This letter is not a license agreement or a release. Think of the letter as a way to introduce yourself to the copyright holder and give them a general idea about who you are and how you want to use their copyrighted material. You can take this letter and modify it to fit your exact circumstances. However, make sure the following elements are included in whatever letter you send to the copyright owner. 1. Who you are individually or as your business. 2. As much information as you can about the work you want to use, the author, title, publisher, date of publication, the portion of the work that you want to use, and any other identifying information related to the work you want to use. 3. How you plan to use the work. Be very specific. For example, if you are going to put lyrics on a t-shirt, you need to disclose that and what lyrics you plan to use, the medium you plan to use, whether it's for commercial or informational purposes, how you plan to distribute the project or your t-shirts. 4. Make sure you ask them to confirm in their reply to you that they own the copyright that you want to use. And if they do not, ask them to give you information related to the current owner. 5. Confirmation that their signature is granting permission for you to use the material as requested. Now let me warn you, they may not grant permission outright, but you can ask them to contact you if they wish to use a license or an assignment. Some authors will give you a blanket permission while others may require a licensing agreement. Just be prepared for that. No matter what, wait to hear back from the owner before you use the copyrighted materials. Copyright owners have the ability to say no, and you should be prepared for that. Given the overwhelming amounts of available content, if you do not get the response you want, or you get a response that says you don't have permission, look for alternatives. Don't ignore the denial and push on with the project as planned. In business, just as in life, you have to adapt to the facts as they are, not as you want them to be. So be flexible and be ready for rejection. A concern that business owners often express to me is that researching the owner of a copyright seems like a lot of work, and they want to know if there's someone that they could hire to do it for them. The answer is yes. There are both private and public services that you can use to do this for you. If you aren't satisfied with using a work that is available in the public domain or under a Creative Commons license, you can hire a service company that will locate the copyright owner and request permission on your behalf. The United States Copyright Office also offers record research services for about $200 an hour with a 2-hour minimum. So why is doing nothing a bad idea? I know that it may seem like a bit of overkill to research the copyright owner, but it's worth it to make sure that you get permission from someone who can actually grant you permission. Don't assume that just because the copyright notice says that a person or an entity owns the copyright, that you are free to rely on that notice without exercising due diligence to make sure that information is correct and up to date. Most of what I'm teaching you in this course is how not to only protect yourself and your business from liability, but I also want you to have internal workflows that you implement in your business before using other people's intellectual property. Having a plan in place makes the process a lot easier and will help you identify potential blind spots in your business. Let's recap. In this lesson, I talked about my process for identifying and contacting copyright owners to get permission to use their creative works. I also discussed using items in the public domain as well as getting permission to use items in the Creative Commons. Your action steps for this lesson is to download and review the JWM Designs Copyright Owner Due Diligence Checklist and the Permission Letter template. Look at your current internal processes and decide how you can implement these steps in your business. All right, I hope you found this third lesson on copyright ownership research to be helpful. Please post your questions or comments on this video in the comment area below. You can also post questions and comments in the private Facebook group for this course. Remember, you can find me on Facebook, Instagram, and LinkedIn, and all my handles for those sites are also listed in the course resources area as well as in your e-notebook. All right, guys, that's it for this lesson. So until I see you in the next lesson, keep building, y'all.